Okay, everybody, welcome to the Apartment Association. Today's webinar is going to be on the status of the eviction courts in Milwaukee County. And we have with us today Commissioner Maria Dorsey, who's the presiding court commissioner of Milwaukee County. She joined the judiciary in 2012 and was appointed the presiding court commissioner in 2014. She supervises the 10 judicial court commissioners, 4 of which are assigned to small claims, and preside over the eviction and collection calendars every week. And then we also have with us Jennifer Hayden, who's an attorney with Tristan Pettit at Petrie and Pettit. And Jen specializes in, among other things, landlord law. And so she will be here on behalf of Petrie and Pettit to offer the attorney side of things today. So welcome. Thank you, Maria and Jennifer, for joining us today. You could, we'll probably start with Commissioner Dorsey. You could give us a quick update of the state of the court right now.
All right. Well, thank you, Christy. Thanks, everyone. I'm Commissioner Dorsey, and yes, it's been quite an interesting, as you're all well aware, how many months now? Since March 13th, I believe, the courthouse actually, small claims court closed down. So in that time, we've had to try to recreate what we do in 400 virtually. So it's been a long process trying to get all the commissioners as well as all the deputy court clerks up and running virtually through this Zoom platform in terms of hearings. So, and then we had the, as you're all well aware, the eviction moratorium, the Governor Evers emergency order. So in the meantime, we got our 8:30 and 9:30 collection calendar up and running through Zoom after figuring that all out. And then we turned our focus to eviction court once the moratorium was lifted. And it's still a work in progress, so we appreciate all of your patience, but I hope I can answer some questions for you today. We've had the commissioners and I, along with Judge Pocan, who's the presiding judge, as well as a deputy chief judge over the civil division, and also Judge Colon, who's the small claims judge. We've had lots of meetings through this Zoom platform, lots of emailing, just to try to figure out between all the federal law that's come down, the governor's orders, trying to figure out how we can help eviction court moving. So with that, we have been doing evictions now since the moratorium lifted, as well as, I should say, the clerk's office coordinating with them, which has also, they've gone through their own staff shortages, furloughs, and that sort of thing. And then we've had to take into account, once the moratorium for evictions expired, Zoom notices had to go out with commissioners' ID numbers and all of that. So that pushed us back a little bit. So I think we officially started doing the 1:30 calendar the week, let me think, it was after June 8th. I remember that. It wasn't that week. It was the week of June 15th we started. So we're trying to clear out the backlog. So with that, I can turn it to Attorney Hayden. If there's anything you want to add, I know Attorney Hayden's been appearing on many of these Zoom eviction cases as well.
Yeah, I mean, I think it's a new process for everyone, and everyone's kind of trying to just work their way through a lot of it. There are some bonuses to it as far as scheduling and timing. We were talking, while we were waiting, that, I can keep working while I'm in, the Zoom room waiting. So there's certainly some bonuses to it. I think, some of the larger issues that we've had are, the inability to work out a stipulation on the spot. The tenant shows up and it's always at the last minute, and where they just need the weekend to move out. Well, normally we'd just sign that in court and that would be that. We just don't have that ability right now. So then those things end up getting adjourned. And I think it, at least my last ones were around 3 weeks out. So, that's kind of a downside to it, but there certainly have been some bonuses. I've certainly had a lot of tenants appearing. So that hasn't been an issue for us. I know another thing that I've heard a lot of from people is sort of managing the 130s and the 230s. And, maybe Commissioner, you could speak to that a little bit, if there's a way that we should be handling that. So far, all my 130s have been with one commissioner. So I've checked in with the clerk and that's been fine. I've handled it a couple different ways. I've asked the clerk, if they can check in for my 230s, or I've had someone else appear for the 230s. Anything from the court on that?
Sure, and I think that was a question that Sadie sent to us ahead of time. When how do you handle when you're assigned to a different commissioner or multiple commissioners for 130 calendar, even 230? And so now, as you're seeing, the commissioners do have their own calendar, unlike when you're in 400, we all do everything. So the best way to go about that, the commissioners communicate with the clerks, and the clerks, there's 3 deputy court clerks assigned to 3 commissioners doing the 130 calendar. And so they're all communicating with each other. So I think the best thing is to perhaps check in with one commissioner first and let the deputy court clerk know that I also have cases with Commissioner so-and-so, and let their clerk know that. If you don't have 2 devices, I know some attorneys I had last week, I was doing a calendar last week. One attorney had 3 devices, and I know not everyone can do that, obviously. He was sitting in his office, he had 2 cell phones, or I don't know what platforms, but he was able to check in to multiple courts. But if you can't do that, we don't expect you to. It's just all about communication. You just have to ask the clerk. I also have cases with, Commissioner so-and-so, could you email their clerk or text their clerk that I'm with you, and I'll jump off with you and log in to them as soon as I can. As long as the clerk knows that in the other Zoom court, that clerk will make note of it. And if one of your tenants appears in that courtroom and you're not there yet, the clerk will know and tell that tenant, well, I'm going to put you back in the waiting room. The landlord is still with a different commissioner. As soon as they come into ours, we'll let you know. So that's how we've been doing it, just through letting the deputy court clerk know, and that deputy court clerk will text or email the other deputy court clerk assigned to the other commissioner.
Yeah, that's what happened to me on Friday. And so Commissioner Martin was able to, his clerk just told the other clerk, and then they just waited.
Yep. And, the way the calendar is being divvied up, there's really not any rhyme or reason. The clerk of court's office does that. And I think one of the supervisors is divvying up the calendar between the 3 commissioners, and then the 4th commissioner is actually doing all the evidentiary hearings. So that's how it's been working out. So if the person in the clerk's office knows that Attorney Hayden has a bunch of cases, she will try to keep all of Attorney Hayden's cases with one commissioner. And so they are, if she has a lot. So they are trying to do that, but it doesn't always work out. Same with our morning calendar. Some of the collection attorneys have 2 attorneys, so then they're able to divvy it up. But they are trying to keep people with the same cases in the same commissioner's courtroom, but it always doesn't work out that way. Are there other?
Yeah, I know I've seen some other questions pop up. Do you have access to those, Christy, or?
Yep, I'm just going there right now. So the first question was, I'm not sure why someone would want to do this, but can we not accept RAP or deny RAP? Can we then do an eviction?
Tell me what
the RAP thing was the 25 million from the state.
So is that what it's called, RAP?
Yeah.
So through community advocates?
No, this is the first one that came through for the 25 million that goes through the SDC.
I think it's being some of it's being administered through community advocates. I will say
that's the 10 million that came through from the county.
Okay, so RAP is through SDC. Yeah. That most likely will be, if it's through SDC, so the question is, if they don't want to accept it, can they still evict?
That.
Oh wait, you went in and out.
Yeah, the question was, can we not accept it, or can we deny it and proceed with an eviction?
Yes, I think it would be treated like emergency assistance. Right. So if a tenant comes into the Zoom hearing and they have information about having applied for it, I mean, it's kind of hard. Normally, you know, we have like when everyone's in 400, the tenant would have the documents from, you know, like a W-2 agency saying they had applied, and then by statute, we have to stop. The commissioners can't handle those cases. We do have to set it over on the judge's calendar for emergency assistance review. So that most likely, yeah, it's my understanding you don't have to take it, but we do have to set it before the judge. So that does delay your case, just like it would if you were in 400 too, unless the judge could have you walk right over. It's very hard now to walk right over because Judge Colon also is doing all of his cases virtually through Zoom. He still has a contested eviction and an emergency assistance calendar, but we can't always get you to hang up with us, dial into his courtroom, virtual courtroom, and hear that case the same day. The clerks do try, so you're aware. So the clerk for the commissioner will email or text Judge Colon's clerk and say, hey, can we kick somebody over to you for emergency assistance? And his clerk, his name is Matt. Matt will let, you know, our clerks know. So sometimes it might be possible to get like a same day hearing, but very unlikely. So then it will delay your case. So I just want everyone to know it's just like in 400, it would delay your case too if the judge couldn't take a walkover. We'd have to give you a date on the judge's contested eviction emergency assistance calendar. So I hope that answered that question. Is that your understanding of RAP too, Attorney Hayden?
Oh, I was just going to say, as to, you know, why you wouldn't want to, you know, I think all those programs are limited in the amount. And unfortunately, if the tenant waited too long and the amount of assistance isn't the full amount, that might be a reason why you want to deny it. Typically, there are strings attached to that you won't proceed with the eviction action if you accept that money. So that might be a reason why someone doesn't want to proceed with it.
Right, and that's my understanding with the community advocates money too. I had mainly pro se landlords all last Friday, and a lot of tenants know about the money. So sometimes I would say to the landlord, do you know about this community advocates money, the 10 million? Because it's my understanding there's $3,000, there's up to $3,000 for tenants if they qualify. And that was with, the commissioners had a Zoom meeting with the county housing that's helping orchestrate all of this. And so that was our people I know are behind more than 3,000. So one landlord he just wanted the tenant to move. Like he didn't even want to worry about if he was going to get the money or not. So it's just, I guess, a case by case analysis for each landlord.
So another question was about stipulations. How are signed stipulations being handled since they can't be signed right away, and then cases are being adjourned even though there's an agreement? And what is the best way that we can move forward with stipulations?
Yeah, and that was a very hard, we still don't have a good answer for that because we obviously need signatures. For a commissioner to review a stipulation, the parties have to sign it. And so I know if you're meeting with tenants and are able to create your stipulations, or I think the clerk's office has copies down there of the ones you normally would find in court. Right. If you come down, and again, they'd have to be scanned in and uploaded. You know, it'd be like dropping off documents, just like you drop off between 12 and 2 with the clerk's office for those that can't upload it through the e-filing process. So,
to include a stipulation when you're initially filing a case?
Absolutely. Yes. If you know that you're already out, you could definitely submit it with your paperwork. That would be fine. Just as if you were walking into 400, handing in all your documents, and you and your tenant have already worked it out. Turn it in, the sooner the better. Also, Mediate Milwaukee. A lot of the landlords probably listening today are familiar with certain days of the week. We had the 2 attorney mediators in court mediating 130 cases, and they often would write up stipulations for the commissioners. Like they would mediate the case, get the stipulation done. They are also working virtually, and they also have been able to help some parties facilitate just doing the stipulations if that's easier. And then I'm not sure how they're getting the signatures, to be honest, but they're also able to upload them as a non-party e-filer. So they have been able to, but I don't know if they're meeting people out in the community or if you're able to get that stipulation to Milwaukee Mediates. They have been able to help people with that process as well. But yes, there's no coming to 400, turning them in like the old days. Some attorneys are having office hours, like last week, one of the attorneys that does a lot of evictions, plaintiff's attorney, he was having office hours for tenants to come in and sign, and then he would upload them. So that's the best we can do with stipulations. We don't have a process where they're, we have them to give to you anymore, except through the clerk's office. I will say, though, if you do get your writ of restitution, the commissioners are able to upload that piece of paper you would normally have gotten in court, just the authorization to go purchase your writ from the clerk's office. So the commissioners have that ability. So now we're able to, if we grant your writ of restitution, we will, it might be at the end of the day because we're doing 1:30, like last Friday from 1:30 to 5, I was doing all eviction cases. And then at 5, I was finished. I went back through my calendar and the writs that I authorized, I uploaded the authorization and got those done, and like commissioners just electronically sign them, and then they should be part of the case. And you should be able to print those off, but you still have to come down to the courthouse to 104 to actually purchase that writ of restitution.
Right. So Amy from Mediate Milwaukee said that they use a product similar to DocuSign that gets e-signatures for stipulations and then
Oh, good.
can be submitted to the court then.
Is she on? Oh, good. I'm glad Attorney Kultz is on if she's just said that, because I can't remember what everybody's process is. So thank you.
And then I will just add, it's my understanding that the Sheriff's Department is still not accepting in-person filings. So then you would be taking that original writ with the authorization, your check, and that Sheriff's Department yellow card and mailing that in instead of delivering it there in person.
Oh, that's good to know, because I know a while back, I think it was, I think Carrie's on here. She emailed me because, we didn't know what the Sheriff's Department was doing, because the Judge Cologne had started issuing writs again. So it sounded like they were waiting, the sheriff was waiting for the court, and Judge Cologne was like, what are you waiting for? We're moving again, So we didn't know what their process was. So that's good to know that, but now people have to mail everything in instead of going down to the safety building.
Right. That was the last information I had. That may, may always be subject to change.
It's probably still true. I'm not sure when the safety building, I see Carrie just wrote, sheriff accepts email when payment is made electronically. Okay, thank you for that. You all know that aspect of it, because once we authorize the writ, we're like, okay, we're done.
It's out of your hands.
We don't have any jurisdiction, obviously, over the Sheriff's Department. So that's good to know. And the safety building, I don't know if it's going to open back up. Some of the criminal courts are opening back up, but I don't know if that involves other, the Sheriff's Department in the safety building. I'm not sure.
And did the county approve a CARES affidavit that could be downloaded yet, or is that still sort of
there
up in
is, as to if it can be downloaded, that I'm not sure, but there was one approved, and I know the clerk's office has copies of it in their office. The court's also accepting the one that Attorney Giese created, as well as and the one that Attorney Nick Toman created for, he works with legal aid, so he represents tenants. They both created one that hits all of the 4 points that the commissioners are looking for. But it's my understanding there is one in the clerk's office that Judge Cologne approved. However, I'm not sure if Paula Black has gotten that uploaded like on the county website. But you know what? I'll email her real quick and see if she'll get back to me while we're doing this.
Is there another question we can?
Looking through here. Mediate Milwaukee is awesome, Tori says.
Yes, they are.
Good. Yep.
So Tori also had a question. The up to $3,000 in assistance is supposed to be paid directly to a landlord. So why can't a landlord have a judge order that the money still needs to be paid to the landlord to the extent of their balance and yet still have tenant be evicted?
And I think that's because of the way the programs are structured. Essentially, you know, the goal of those programs is to keep people in their housing. So they do want it to be conditioned on the fact that the tenant's going to stay in the housing. I understand from a landlord's perspective, you're saying, well, the money is owed, so, you know, why can't I collect it? But if that's not the balance, you know, or the tenant would still be subject to eviction. But that's just the way that they structured those programs, because the purpose of the programs is to keep people in their housing. So they want to spend that money where it would be most likely to keep people in their housing. I think that's probably the best way to explain it.
Right, that's what I was going to say. Yep. Because once you have that money, even though it's still rent owed, but the CARES Act was to prevent homelessness during this pandemic. So if you're going to take the money for back rent and still evict them, even though, you know, by law, you technically can do that under our law, but this is federal and there's strings attached when you take the money.
And then Joe is asking, are commissioners still requiring a legal defense from tenants when objecting to the landlord's complaint?
When objecting to the landlord's 5-day or notice? Well, you know, it's by case. If the commissioner hears something that they believe rises to that level, they'll set it before the judge. And I know during this time, it's been, you know, it's been subjective. Every commissioner is a little different in what they believe the legal defense is. And so if there's something that the commissioner believes the judge should review, you know, they'll set it before the judge for a contested eviction. It's not really a one size fits all type of analysis. So yeah, every commissioner is a little different, and Judge Colon has let the commissioners know that if there's something the commissioner believes he should look at, he wants it set on his calendar.
A couple other questions are specific to RAP funding, which is not exactly what we're talking about here. So I'm just trying to sift through these. Another thing that came up at one of my cases was, now I'm trying to think what it was.
I wrote back.
Now I can't remember what I was going to say.
That's all right, Chris. A problem with the CARES Act affidavit, maybe, or something that wasn't available on CCAP?
No, I had the double scheduling. We already talked about that. Oh, so actually the ones that were double scheduled for me last Friday, they had never even been sent to Zoom instructions. I only called because I didn't have them and I knew that I needed them, but there was not even a note in the case, because I see most of them say Zoom instructions were sent on such and such a date in CCAP. And both of these cases, neither of them showed that the instructions had been sent.
So you actually had just a normal notice giving you a court date?
Yeah, I hadn't got the more current one with the Zoom information, and I actually had to call to get the numbers.
Okay, so you were able to call. Yes, so if that happens, if you know you got a regular notice that looks like, you know, you should walk into 400 and have your case, definitely if you didn't get a Zoom notice, that could have been a glitch, but I know there are some cases where even landlords and tenants or even our morning calendar have said, oh, I just got the Zoom notice this morning. So they've had the clerk's office, as I said, I think Attorney Hayden and I were chatting a little bit before this started. They've been inundated with, you know, documents to scan in. They have to get Zoom notices out. So first they send out a notice of hearing, and then they have to set out a Zoom notice once they divvy up the calendar. So it's a lot of work, and they're so short-staffed based on this pandemic. Some clerks are working from home, some can't work based on childcare issues. So they've just been short-staffed, John Barrett's office. So that's really, you know, what's been going on. So some Zoom notices have gotten out late. Interesting, when people get them the day of, they're still able to call in, which is nice and still hear hearing. But if you get a notice of hearing without a Zoom, definitely do what Christy did and get the ID number, because as you are well aware, 400 is not open yet.
Well, and just as another heads up, the number that's on those meeting things is not a good number. It gives you like a mailbox that can't even take messages. It was like the number to call the court, and it didn't. Nobody was even answering that number, so I had to run around and like try and call the clerk's office and this and that. And finally got somebody who could give me the 2 meeting IDs.
Do you know what? So you originally called 278-5101?
Yes, and that number is not good.
I was told that number was forwarded to 104, the clerk's office.
Well,
because
nobody was picking it up.
Nobody picked that up. I wonder if they lost staff to even do that. So do you know the number you did call? Because
hang on one sec. Let me just find the case from Friday.
now Carrie said that she hand delivers a copy of the Zoom instructions to our tenants personally. So that means at least you're getting them. So yeah, most of the commissioners are saying that the tenants are showing up, you know, with these Zoom notices. They're calling in.
Yeah,
So people are hearing.
first ones the tenants did, but the 2 the judgment hearings, 2nd and 3rd from last week, they did not show up.
Yeah, the 2nd and 3rd, I had that experience last week. It seems like more are showing up though than maybe anecdotally that would come into 400, but because it's easy just to call in. But right, we have more defaults. And then what we're doing, if you do have a default prove up for a 2nd and 3rd causes, I think I mainly had attorney cases. So the itemization of damages was uploaded with pictures and invoices just so I could quickly assess and grant the judgment. So if you're able to do that, if not, some landlords just decided to get a judgment for rent that was pled in the summons and complaint. And you know, we're satisfied with that. So if you're able to get documents and invoices and even pictures, you know, uploaded or turned in, copies turned in, although they are behind in scanning, that will help with us in terms of 2nd and 3rd causes, again, because then it will be in our e-file or our electronic case. I'm just going to go back to that. The affidavit for the CARES Act has not been uploaded yet, but the clerk's office is sending it to the county IT guy to make it a fillable document. So hopefully that'll be done relatively soon, but there are hard copies in the clerk's office. So if you're filing a summons and complaint in person, you know, grab some. And I can tell you, you only need the affidavit that your property does not fall under the CARES Act if you commence the action after May 26th. So if you started your eviction and your summons and complaint before March 27th, before the moratorium went into effect, you do not need an affidavit saying your property does not fall under the CARES Act. But if you commence your action after May 26th, you do need an affidavit saying your property does not fall under the CARES Act. If your property falls under the CARES Act, the commissioner, you can't file an eviction until after July 25th. I don't know if there's been any update to that. Maybe Attorney Hayden, do you know if there's been any update to that?
Not on the timing, but I did want to clarify if it's a CARES Act property but a non-rent breach.
So if it's a CARES Act.
If it's a CARES Act property but a non-rent breach, it's my understanding that we wouldn't need the affidavit.
Okay, non-rent breach. Let me, because I know we're focusing so much on, and I'll have to, because Judge Colon has given us some guidance on that. So let me just make sure that have you already had that with Judge Colon?
I have not. In fact, I have one scheduled, I think, at the beginning of July.
All right, I'll have to make sure we're all on the same page there, but I'll write that down and send that out to the commissioners and Judge Colon and make sure we're all on the same page and agree with that. But that's your understanding based on your research, and I know you've written about the CARES Act. Okay, all right. Did that answer people's questions, if there were any, regarding the affidavit of the CARES Act when it's needed? And when it's needed, it also has to cover basically 4 points. But the affidavits that we've talked about today that the court's accepting all cover those 4 points in terms of whether your property falls under the different categories. All right, any other questions?
I think we've pretty much covered everything in the chat.
And I can tell people just from, I know some people are like, when is 400 going to open again? Here's the process. The chief judge has been obviously working around the clock since all of this happened, and they're focused right now on opening next week, Monday, about 6 criminal courts. And so to the public, with all the social distancing, the courtrooms, the courthouse has been marked up, only 2 people per elevator at a time. Everyone has to wear a mask, and there's only going to be so many people allowed in a courtroom in those criminal courts. And so the judges will be rotating their calendars through those 6 courtrooms, because normally there's, I think, 20-something criminal courts. So there's going to be like 1 homicide court, 1 domestic violence court. So the judges assigned to those divisions will rotate through those courts. There's going to be cleaning supplies in the courtrooms for people to clean after each case. The county cleaning staff do a deep cleaning every night, of course. However, once those open up on Monday, the chief will obviously see how that's going. And then she really does want to focus on small claims court, because obviously we're the highest volume court in the courthouse. And we know the backlog's been great and very difficult for everyone. And, doing Zoom hearings, it's been very hard to duplicate what we do in 400 and put it in a virtual format. Just so everyone's aware, the first 6 to 8 weeks that we shut down, we had to go from commissioners not even having any type of remote access or laptops to work from home, to creating, to getting that all in place, then figuring out how to create courtrooms virtually and get things done. So we have been, just so everyone's aware, working every day. We've had multiple Zoom meetings, and I supervise 7 other types of courts. So it's been trying to get all those courts up through Zoom. But the chief really does want to focus on this court. The impediment to focusing on this court opening up in what they're calling phase 2. Phase 1 is the criminal court starting on Monday. Phase 2, small claims, we were hoping would be in phase 2, and the chief wants it to be the impediment is our volume, because the clerk of courts is trying to figure out, with the numbers of cases filed, how do we divvy that up? Like, how do we say, Attorney Hayden can come into the courtroom with her clients and defendants on those cases and do them in person, but we can't let, some other attorney, they got to keep theirs on Zoom. Like, how do we figure out that process? Because we can't have everyone in the courtroom at one time. Because of social distancing and all of that. I mean, the hearing rooms are great because we can stay 6 feet apart. Each hearing room, 3 out of the 4 hearing rooms, before everything shut down, we were actually going to go to a clerk in each hearing room and get entries done real time. So you'll see new desks in each 3 out of the 4 hearing rooms. That's where a deputy clerk's going to be sitting. And we've got plexiglass. When you come back into 400, there's already plexiglass that's been set up in front of the clerk that calls the calendar. On council table, there's plexiglass, but we still haven't figured out how to actually decide how we split up calendars and who comes in and who doesn't. And if there's another room in the courthouse where we could have, maybe we could call it an overflow, or just a second small claims courtroom where fewer people could be in that courtroom. The chief's looking into all of that. So once a week I get updated from, usually, sometimes it's canceled because the chief is on a million different meetings, but once a week, she talks to the presiding commissioners in each division and tries to keep us updated. So that's the latest information I have about 400. So we're working at, she's working on it with the clerk's office in terms of how to do that. Someone just asked, let's see, down, I think it said, did it say down 40% since? Nobody's feeling like a slowdown, I can tell you that.
Evictions are down 40% year to date by volume.
Okay, the filings. Well, and everything is slower also on Zoom. I think before we started, I was talking with Attorney Hayden and Christy about what happens, as some of you are well aware because you've already appeared by Zoom. the deputy clerk has to check everybody in from the waiting room, and each clerk's a little different. We've had some new clerks training during this pandemic, so that's been hard because, as you know, small claims, it's a high learning curve for any deputy clerk. And so, like the clerk I had all last week, Crystal, she would check in a few people, and as soon as we had a match, like if we had Attorney Hayden and we had, you know, 2 of her tenants, we tried to get her cases done right away. And then Crystal would say, all right, Commissioner, I'm going to check in a few more people. Then I'd say, all right. Then she'd check in a few more people. And so that's kind of how we have to do it. But it does take a while because the commissioner can't do anything while the clerk's checking in people, because she's got to let that person into the waiting room along with, you know, both parties. So that's why, although we might be down maybe case filings, the whole Zoom platform is very slow compared to maybe in real time when we're in 400. Are there any more questions about the process? Oh, you're welcome, Joe. Oh, Christy's on mute. Are you on mute, Christy?
I'm here now. Sorry, we had to take this.
Are there any more questions?
There's just like one.
Sam, I just joined a bit late. Not sure if this has been covered. Oh, go ahead, Christy. I can't read the rest of the question. I only see.
He has a money judgment hearing scheduled for 7/1 at 2:30. What should I do to prepare and documents I need to submit beforehand?
Yes, good question. I did talk about that a little earlier, but I'm happy to repeat it. If you have a second and third, if you have an itemization of damages, if you have invoices, if you have pictures, I'm not sure who Sam is, but if he can get them uploaded, if he's an e-filer, get all those documents uploaded right away. So the commissioner has those in their electronic case when they pull up your case for that hearing. If they have all that, you should be able to go forward. If your tenant shows up, former tenant, I should say, you know, it'll be just like as if you're in court. The commissioner will go through the itemization of damages. If you're able to get that copy to your former tenant, you know, if there's no resolution, you'll get an evidentiary hearing. If there's a resolution, the court will grant a judgment. The only thing we don't have, if you want to work it out with your tenant, like stipulation for second and third causes, we don't have the ability, obviously, to hand you that form that you'd get in court to go ahead and write up the agreement. That's something you have to work out with your tenant ahead of time and anticipate that and get it uploaded or get it, you know, down to the clerk's office so they can scan it in. So that's the earlier the better with whatever documents you can get, because as Christy explained earlier, she walked some documents in and she's still waiting for them to be uploaded. The clerk's office is behind. They've been inundated with documents, so they're behind with scanning those in and getting them into getting them into the court file. And I don't know I know they've, you know, I think slowly they're able to bring some more clerks back from furlough and other things like that. To have more staff, but they've been hit hard with staff shortages. I think somebody else had a question. Can I give an example of legal defense for not paying rent? You know, I'm going to turn that question over to Jennifer Hayden, Attorney Hayden, because to me, that's more of a giving legal advice type of question. She might be able to say what are some of the defenses that she's been involved with.
Yeah, you know, as the commissioner said, there's going to be some variation between commissioners on as to what they consider a legal defense. That's, you know, just the nature of dealing with human beings and in things. I guess the first example that comes to the top of my mind would be some claim of a partial rent abatement or something along those lines. There, in my opinion, there aren't many when it comes to rent, but it does depend on the particular facts and circumstances.
Right. Rent abatement. You know, sometimes it depends what the tenant says. If there's been maybe they believe there's been another agreement. Sometimes it's about the service of the notice. So there can be a contested eviction if there's a challenge to the service of the notice. That can, then we'll put it before the judge, as well. Or trying to think of, I know the law did change, trying to think of some of the other ones, because we don't, usually it's the rent abatement. Attorney Hayden, do you think of any others that you've had? I just don't have the.
Yeah, I think I don't know, the abatement's probably the typical one, unless it's some kind of, either wrongful eviction or, something along those lines.
Like a retaliatory or I did hear one woman last week, I don't think we set it for a contest because it ended up working out. But she said she tried to pay within the 5 days and the landlord, wouldn't
accept.
make himself available to the money, or the normal process he normally picked up the money he wasn't doing. And she had 2 money orders. I mean, I'm hearing all this through Zoom. I just recall it because it was the first one I had heard in a while, where she said she tried to pay within the 5 days. She had 2 money orders with him, and that would have caught her up, and he, for whatever reason. So, but then it ended up working out. But that might have been one where I would have put it before the judge. Because then obviously, as you're all well aware, if someone catches up within the 5 days, no eviction can be filed.
Right.
If you're the 5 days. So those are some examples.
I have had some where it's, I talked to, so-and-so at the landlord's office and they said I could pay it later. And, some of those.
Yeah. Those are hard.
Yeah. Sometimes.
Yep. Because often tenants don't realize, and I don't know if property managers or whomever is giving that information, if they pay a few days late, they think they're all good, even though the eviction may have already been filed. And then when they get into the hearing, the landlord's like, no, we still want the eviction. And the tenant's like, wait, you took all of my money. I know it's already, the 5 day already expired. So technically maybe you're entitled to the writ, but maybe the commissioner's like, well, wait a minute, was there some promise not to go forward? And sometimes the judge does want to see those. Is that a legal defense? Maybe to the commissioner, it is because of whatever they heard from both parties. So that might be set for the judge. All right, let's see. Did the tenant pay any rent since the 5 day? Was that even considered? Is that the question for me on my case last week? That I don't remember. As I said, last Friday I was on the record, or not the record, we're not a court of record, but from 1:30 to 5, I did all 1:30. I didn't have a 2:30 calendar so I don't remember to answer to that question if they had paid any more rent going forward. I can't remember. And the 5 day may have been May 27th, so there may not have been much more rent any other month, or maybe it was May and June. I can't remember, but anyway, the issue was she tried to pay within the 5 days. All right, anything else? All right, I will look into, I'll email after we get off the, just about the CARES Act, and if a property does fall under the CARES Act, however, it's a non-rent breach, so not a 5 day for rent. Do you need the affidavit? And Attorney Hayden believes that you do not legally, so I just want to make sure that commissioners and the judge are all on the same page. Perry's got a question. What is needed to show that an eviction is necessary for safety reasons? Ooh, now that's a question for Judge Colon, because he's been handling all of those. Well, that was more, I guess, Carrie, just to understand, I know during the moratorium, Judge Colon was handling evictions that were allowed under the moratorium for emergency reasons like domestic violence. I think that was the main thing, but we didn't handle any of those. So I don't know, Attorney Hayden, can you shed any light on that?
I think all of those got set for the judge, and that was during the Order 15, the governor's sort of ban on evictions, and it allowed only evictions based on the imminent risk of a serious physical harm. So a lot of them were domestic violence or, some type of really extreme issue. I think the judge said he had a handful of them, and he did issue some writs. At this point, it's my opinion that we'd sort of be back to a more normal procedure.
Right. Right.
The 5 day for criminal or lease breaches or, or those.
Yeah, I believe that they needed a signed affidavit stating the threat of imminent harm.
They
Okay.
did at the time, yeah.
Yeah, I mean, so Carrie's question, threatening lives of landlord harassment, but now the moratorium's over, so if that's the case, I guess I would ask Attorney Hayden, would that be considered a breach of the lease, harassment to a landlord, or imminent danger to a landlord?
Right. In most cases, I would think, yeah, it would be a breach of some term of your lease. There's, some term or provision, hopefully. Otherwise, we do have the 5-day for criminal activity as well, if it rises to that level.
Right.
So a police report or something could be used.
Yeah, police report would always help. And obviously, if you're feeling threatened by someone, yes, definitely contact the police if it's something imminent like that. All right. Is there any other questions?
It looks like no more questions at this time.
All right. Well, I can say on behalf of all the commissioners, we do appreciate everyone's patience, and we'll try to. I know Commissioner Vosper's still on the record from her 9:30 calendar, or not on the record. She just is finishing up her Zoom calendar, so now she's got to start right at 1:30 doing her eviction calendar, because we're trying to cut down the morning numbers, so commissioners can get through their calendars so they can jump right in, have a little break before their 1:30 calendars. Let's see, is there a date set? Someone just asked a question about the sheriffs.
Yeah, I don't know the answer to that.
Yeah, was it a date set for them to go in
For them
person?
to reopen, yeah.
That I do not know. I don't know if anyone out there has that information, maybe through any contact with the sheriff's department. And Judge Cologne didn't know as of last week either, because I asked him, or whenever I got that question from Carrie, I sent it to Judge Cologne, and he's like, he thought they were up and running, so he was shocked too at the question. Actually, and I don't know who's over I don't know who's there, who the civil process divisions, Amy Colts has something. Oh, Mediate Milwaukee is available to help parties work out stipulated agreements. Is there more to that?
Yes, prior to court. If you don't want your case adjourned and you're open to working out a stipulation with your tenant, they encourage landlords to contact them as close to filing as possible. They're able to assist with drafting stipulations and getting signatures for parties that work through their program. All communications are via phone and email. Their phone number is 414-939-8800.
Yep, and that's Milwaukee. Mediate Milwaukee. I always say that backwards. Yes, so if you know that you're going to probably work it out and want to do that without having to come down here and file an eviction, they can help you work that out as well. If landlords, do you want to read the question? I can't see the whole question.
Yep. If landlords want to work out stipulations with their tenants outside of court without Mediate Milwaukee, are there any forms to help them do so? I don't believe the stipulation form is one of them that's available online.
Right.
Dawn, if you email me, I could scan you a blank one.
Thank you. And I don't know if Attorney Colts, even if you don't want to involve their mediators, if she's got one that she can send out. So, but Chrissy, you're able to send someone a blank copy?
I have a blank one. I think I have one left.
Thank you. And I think there was one other question. Did Carrie have another question?
She was asking about if legal aid has access to look at e-filing to determine who needs help.
Oh, are you talking about the Eviction Defense Project, perhaps? Legal aid,
Yes.
I don't think I'm not sure. Or you're talking about EDP. Okay, Eviction Defense Project. Yeah, they're through legal action. And we've been working with them as well to get them up and running on Zoom. So they are getting some referrals. So if your eviction gets adjourned, the commissioner may give the tenant, if the tenant's, inquiring about an attorney, or may give the tenant EDP's information. They are scheduling, but see, EDP they have to screen tenants to see if they qualify, but a lot of tenants do qualify for their services.
Mhm.
So if your eviction, we don't have the ability for them to pop right into the Zoom hearing. We've had many, meetings with them as well to try to see how they can get up and running by Zoom. So we haven't figured out, or they haven't figured out a way how they can just have an attorney waiting, because all their attorneys are volunteer attorneys waiting to see if the commissioner says, hey, here's an attorney, because then that attorney would have to then, basically what's called an e-form them and see if they qualify for their services, and then read the complaint. They can't just pop into a Zoom hearing because they won't have any of the documents. They won't have make sure the person qualifies or any of that. So again, this whole Zoom platform delays everything. But they are available, but it means adjourning the eviction for an adjourned eviction. The commissioner has to get the tenant's information over to Rafael Ramos, the director of that program, Attorney Rafael Ramos, and they'll probably give the tenant the phone number just to follow up as well. So they are out there, but I don't know if you have an incentive to want your tenant to be represented, you could also call the Eviction Defense Project and give them the information. They'd be more than happy to take it from you. I think we had another question.
Brian was asking about when the courts were expected to reopen, or if Zoom was going to be the new normal. And I just responded what you said earlier about the concerns about distancing requirements and that you're figuring out.
Yeah, just real briefly again, expect Zoom to go on for quite some time. The holdup with small claims is volume and numbers of people, and how to recreate the courtroom to, abide by all the guidelines that the county has adopted. And mainly the problem in small claims is social distancing in the actual courtroom itself, not so much when you come back to the commissioner. And also the hallway, like people are packed out in the hallway, people are wheeling and dealing out in the hallway. So all of that we can't have anymore. So that's been the holdup. But the chief, as I said, is focused on getting criminal cases up and running. Jury trials have shut down. So you've got people sitting in custody who are, on criminal cases, whose due process rights are, they're innocent until proven guilty. So they've really focused on getting criminal courts back up. And then their focus is now going to shift to small claims. But I can't give you a date. All right. Any other questions? All right. No other questions? I think we went almost the full hour, right?
Yeah. Thank you, ladies, so very much for all of your information and for, helping keeping everyone informed. We appreciate it. It's a crazy time.
It is a crazy time. We're talking, there's some bonuses, there's some downsides, but I'm sure we'll all just keep working our way through it.
Yep. And again, we thank all of you for your patience. I know it's been tough with not only the pandemic and then the moratorium as well, and trying to keep people in their homes, but also keeping you all paid the money due as well. So if we have to do this again, if we're still on Zoom after a while, I'm happy I'll just have Christy reach out.
Yep, for sure. We might have to do another update at the end of July or August when we get to the next phase of things.
Sure, that would be great. All right, take care, everyone.
All right, thank you, ladies.